Hi, I'm Jerry Clinch, owner and founder of Clinch Law Firm LLC. My office is located in York, Nebraska, though I provide services to individuals across the state. I offer in-person, telephonic, and virtual appointments for clients and potential clients. Appointments can be made online by visiting my website, www.clinchlawfirm.com, using my convenient appointment scheduler, or you can always call in at 402-908-5699. One of my primary areas of focus is estate planning. Today, I'm intending to provide you with some education regarding estate planning in Nebraska so that you're aware of your options and know what you can do to achieve your goals. So let's go ahead and dive in. So what is estate planning? Estate planning, essentially in a nutshell, is a process by which a person can provide for themselves and for their loved ones through a period of disability, leaving what a person wants to whom they want, minimizing taxes and avoiding unnecessary attorney fees, caring for themselves and for the loved ones, sharing their hopes, dreams, values, aspirations, and such with loved ones once they're gone, and supporting causes that are valued the most. What is estate planning? Continue. An estate plan is a combination of legal strategies that addresses clients' concerns. Now, typical concerns and or goals in the estate plan may range from planning for minor children. That's generally very important for, young adults or really anybody that's got minor children. Avoiding going through probate. That is certainly a concern that many people have, and it's possible to do so if you do the right estate planning. Making things as easy as possible your family. Making sure that everything is set up in such a way that you have the least amount of family fighting that could possibly come about. Unfortunately, money does do crazy things to a family, and going through a probate is, something that can result in family being pretty cynical and negative. So if you do all the planning to set things up so that that doesn't happen, fantastic. Avoiding guardianship and conservatorship. In Nebraska, if you or somebody happens to become incapacitated and they don't have the proper documentation in place, then the court's going to have to get involved, and a guardianship and or conservatorship is going to have to be set up. Guardianship is essentially making decisions for the individual. Conservatorship is generally working in tandem, but concerns when there's a lot of money involved. Also, protecting your beneficiaries, allowing children to grow into their inheritances. So let's say you've got yourself a child who's in the neighborhood of 20 years old or so. Myself personally, I was not incredibly responsible when I was that age, but if you happen to pass away, leaving a 20-year-old child behind, and they suddenly inherit a few $100,000, maybe upwards of $1 million, it will not be surprising if that money just disappears because they get it outright, spending it on frivolous things. If you want to avoid that, you can set things up so that they aren't able to get the money until they reach a certain age. Or maybe they only get a specific amount once a year or multiple times a year. But there are a lot of options available. And also another pretty huge thing that a lot of people consider is estate planning for special needs children. If you've got a child that is handicapped mentally or physically, you may be concerned what's going to happen with that child. Do you have to disinherit them because of Medicaid concerns later? And the simple answer is no. You do not have to disinherit your special needs child with the right planning in place. All right, so let's go ahead and move on. So what happens if you happen to die without a will? That is called dying intestate. Simply put, it just means you've passed away without a will. In Nebraska, and really every other state, the state has already determined what's going to happen with your property in the event that you pass away without a will. They've already set things up. You're looking at family members. If you're married, things are going to go to your spouse. If you've got children involved, that changes things up as well, especially if they are not biologically related. We'll say it's a second marriage. Does muddy things up just a little bit, but long story short, intestacy, if you die without a will in Nebraska, the state has already decided how your property is going to be distributed. Now we're going to go ahead and discuss a foundational estate plan and what that entails. Foundational estate plan is exactly what it sounds like. That is the starting point, the basis for a solid estate plan. And what that's going to include is either a living trust, revocable living trust, along with a pour-over will, or last will and testament. Both of them do different things. We're going to talk about them as we move on throughout this program. Additionally, a foundational estate plan will contain durable power of attorney, dealing with your finances, medical directives, otherwise known as healthcare power of attorney, a living will, and HIPAA release, just to make it easy, or as easy as possible, for the individuals that need to get your medical information to get it from any covered entities, hospitals, your doctor's office, wherever it might be necessary. And then funding documents, if applicable. We'll talk a little, funding documents are really associated with revocable living trusts. We will talk about that a little more later. So I guess that is where they would be applicable. So now we're going to go ahead and dive into what the difference is between a will and a revocable living trust. A will, simply put, is a legal document that sets forth your wishes regarding the distribution of your property and the care of your minor children, if there happen to be any. Will goes into effect only once you pass away, has really no bearing on anything until you die. A revocable living trust is a trust document that's created by an individual or individuals, like a single person or a married couple, that can be changed over time. Revocable living trusts can be used to avoid probate, protect privacy of the trust owner and beneficiaries, and help to minimize estate taxes. The term revocable in and of itself just means that you retain the control of the assets that are in your trust while you're alive, and you can amend or change the terms of the trust at any time. Here we are with a table that provides some more information as far as the difference between last will and testament or a revocable living trust. There again, will only takes effect at death. Revocable living trust allows for planning during the lifetime. Last will and testament, again, since it only goes into effect upon death, does not do anything as far as incapacity planning. Trust agreement, on the other hand, can provide for incapacity planning. There's just a lot of things as far as wills are concerned. You have to have a personal representative that is appointed or approved by the court. The will has to be proved up in court. If a trust is properly put together, then you can avoid probate entirely unless there's some kind of crazy dispute that can't otherwise be resolved. But it does allow for, I guess, a lot of additional options. Now we're going to go ahead and continue on to page 2 of this. Some more differences. Your will, for example, going through probate, gets filed in its public record. A trust, unless something crazy happens, generally remains private. The will, you do have to go through probate, and the administration can be expensive. Attorneys, unfortunately, do charge for their services, as most people are aware, and that is the case for probate cases. So if you do have to go through that, you're going to be looking at some additional fees that may not be applicable if you had had a trust set up. Now, this is a pretty typical question when you're talking about wills and trusts. Oftentimes people want to know, which is better? I mean, what is better for me, for my personal situation? That's really what it comes down to. Your own personal estate planning Goals and desires. In my opinion, everybody should have at least a will in place, and this is especially true if you happen to have minor children. In the event that you don't, if there's no will in place, you and your spouse happen to pass away leaving minor children, somebody is going to have to care for them. In the event you don't already have it set out who's going to do so, then the court is going to have to be involved, and it's going to amount to a judge ultimately making a decision for who is going to care for your children based on whoever's available, the information that they get. Unfortunately, that does mean that if somebody petitions the courts to act as guardian for your children, and it's not somebody that you would have chosen, if they ultimately get it, that's just an unfortunate side effect of not having a will to demonstrate. So I would highly suggest that anyone that does not have one who has children at least get a will set up for that particular purpose. Revocable living trust can do a lot of things that wills don't, such as avoiding having to go through probate, protecting your beneficiaries. We've already talked about this a little bit, and that's assuming that your trust is properly funded, because your trust can only control assets that are placed within it. You know, a trust is similar to a 5-gallon bucket, and the trust creator takes a hold of it, places whatever it is they want inside that bucket, whether that's your vehicles, money, stocks, bonds, any property that you would happen to have can be assigned or placed into your trust for funding purposes. Now, I guess the biggest consideration between opting for a will or a trust is the cost. I mean, plain and simple, it does cost more to have a revocable living trust prepared, and then as far as funding and maintaining it throughout your life, really it depends on what you get and what you have to ultimately put into that trust. Now, if your trust is not properly funded, or let's say you've funded it correctly at the outset, you've got the trust set up, you've got your house put into it, everything that needs to go in your trust is in there, fantastic. A few years down the road, you get yourself a windfall of money, or just you happen to purchase another house. That house does not get transferred into your trust. That's a problem. In the event that something is left outside of your trust once you pass away, it's unfortunately going to have to be probated unless there is some kind of an exception that would allow for that not to take place. Thus, it is always a good idea to maintain contact with your estate planning attorney and communicating with them during any major changes that take place in your life, such as big purchases, spouse passing away, child passing away. Those are all big reasons to get in contact with your estate planning attorney to see whether or not you need to do any updates. Now we're going to discuss a little bit some of the additional necessary documents for a solid foundational estate plan. That'll include your durable power of attorney. That right there is an agreement between you and an agent that you choose that designates financial duties that the agent will perform in your stead in the event that you are incapacitated, or you can also set things up so they can do things for you just in the event that you're not available to do it. I.e., you're out of the country on vacation, you need your agent to do something for your farm or something of that nature, or sign a check, whatever it may happen to be. Depending on how you set things up, they would be able to do that for you if you set it up in such a way. Healthcare power of attorney, sometimes also called advance directives. The same essential thing as a durable power of attorney, except this concerns your medical care or medical decisions. So in the event that you're unable to make medical decisions on your own for whatever reason, you're incapacitated, you're in a coma, you've got dementia, and you can't make reasonable decisions, then your healthcare power of attorney would be able to step in and do things on your behalf. A living will is the next document that we'll be talking about. This is not to be confused with a DNR, which is acronym for do not resuscitate. A living will is concerning end-of-life care. So let's say hypothetically that you end up in a coma. You are, for lack of a better term, a vegetable. You won't be coming out of the coma, and you're just going to be hooked up to machines for the rest of your life. Living will can set up directions so that that doesn't happen. So if you don't want to be hooked up to a machine for the rest of your life, if there's no chance of getting better, living will dictate essentially that you would like the plug to be pulled. And really, I guess one of the biggest reasons that I think a living will is a good idea, if that is what you would like to do in the event that you happen to be in a persistent vegetative state, that's essentially taking that decision out of your healthcare power of attorney's hands. So let's say your spouse is your healthcare power of attorney, you end up in a coma, you're not going to come out of it. Your spouse then doesn't have to be the one to make the decision to pull the plug because you've already dictated that with your living will, assuming, of course, that that is what you want to happen. And then finally, the last piece of the puzzle is a HIPAA release. This just allows medical entities, hospital, doctor's office, whatever it is, to release medical information to whoever it is that you've designated via this HIPAA release document. Now we're going to go ahead and dive into some of the critical estate planning factors that one should consider in Nebraska. We've got 4. Nebraska state inheritance tax, the federal estate tax, long-term care expenses, and estate administration costs. And we'll go through these individually. So first we're going to go ahead and start off with the Nebraska state inheritance tax. Unfortunately, once you pass away, the state of Nebraska has placed a tax on, I guess, what your beneficiaries are going to obtain via inheritance. Now, for your spouse, there's no state inheritance tax, so that just automatically goes over to your spouse if you happen to pass away. But as you start looking at different classes of heirs, there are, well, unfortunately, taxes that have to be paid. Class 1 heir, for example, they are charged 1% on any inheritance over $40,000. And that includes parents, grandparents, children, grandchildren, siblings, immediate family, essentially, plus a few others. Class 2 heirs are charged 13% on any inheritance over $15,000. So if, we'll say, you give your uncle $15,000, then there won't be any inheritance tax. But if you give him $20,000, then that $5,000 between 15 and 20 is going to be taxed at 13%, which gets paid to the state. And then finally, and unfortunately, Class 3 heirs, these are your unrelated third parties. It is 18% on any amounts over $10,000 for unrelated third parties. Now, this doesn't necessarily include charities, so if you've got some charities, there isn't going to be any inheritance tax that would be associated with those gifts. But if you're just giving, $20,000 to your best friend Bob is going to get hit pretty hard on that $10,000 tax at 18%. Now, up next, we're going to go ahead and talk about the federal estate tax. Now, Nebraska, the state, does not actually have an estate tax. All it has is that inheritance tax and, of course, income taxes as well. But the federal estate tax, realistically, 99% of people will not have to worry about there being a federal estate tax unless it gets dropped, the exemption gets dropped dramatically, which is a possibility. As of this year, 2021, if a single person's estate is worth $11.7 million or less, then there would be no federal estate tax to worry about. So one single person, $11.7 million or less, no estate tax to worry about. If a person's estate is worth more than $11.7 million, then the federal estate tax would apply to anything in excess of that $11.7 million. There is a basis as far as how they figure that out, but it maxes out at 40% of anything amounts $1 million or greater. So, i.e., if you happen to have $1 million, you're looking at 40% being taxed. I'm sorry, $12.7 million. That's $1 million over. You're looking at a huge, huge amount of tax on that 1 million, 40%. So $400,000 is going to be going to the government in that kind of a situation without the proper planning in place. The solution for this is simply just analyzing everyone's situation individually and determine whether or not we need to do a gifting plan. So you've got too much money, it's going to be taxed. What can we do to get rid of that, some of that money, or distribute it now so that there won't be any taxes incurred? Up next on the list is long-term care expenses. Unfortunately, with humans having an increased lifespan, more people are going to end up in the nursing home or an assisted living facility. The number of Americans age 65 or older that will require nursing home care is likely to increase by up to 75% from where it is by 2030. The average length of a stay in a nursing home is around 3 years. And in Nebraska, at least, the average cost is close to $300 a day. I believe when I looked it up, $290. $290 is about the average in Nebraska. So you're looking at about a $300,000 risk in the event that you end up in a nursing home. Now, solution to this would be long-term care insurance. This isn't the cheapest thing in the world. I mean, you may be looking at a couple $1,000s, I believe, potentially per year for long-term care insurance. And as you grow older, the insurance does increase. However, if you've got yourself a pretty huge estate and you want to avoid this potentially $300,000 risk, because you're going to have to pay for that assisted living or nursing home if you've got the money to do so. If you don't have any money, all things going well, Medicaid's going to take care of it. But the state is not just going to pay for things if you've got assets that the state can take. And there are a number of things that the state can do to recover assets in the event that, we'll say, you manage to get Medicaid to pay for something, and then later it's found out that you transferred your house to your son for next to nothing once you learned that you were going to have to go to the nursing home. State of Nebraska is going to do what it can to get that money back. So planning in advance is always the best way to go about things. The next thing we're going to discuss is estate administration costs. Now, fortunately, if you have to go through a probate, unless you are quite savvy, you're going to end up needing an attorney to help you out. Attorneys may charge a percentage of the assets of the estate, 1%, 2%, depending on the size of the state, that can be significant. In the event that you're not with an attorney who charges a percentage, it seems very common based on my practice and speaking with other attorneys that $300 an hour or more may be what the hourly fee for an attorney who's going to handle a probate matter. So what that means is estates that have to go through probate are going to have, in all likelihood, significant fees. If you plan correctly, using, for example, a fully funded revocable living trust, then you can avoid probate and you won't have to worry about those fees going to the attorney. You still have some trust administration that needs done. However, your trustee, it's certainly possible for them to do that by themselves or just seek out an attorney for a few select items instead of having the attorney pave the way for the probate proceeding. Okay, so now we're going to talk about something, a big concern, I suppose, that I have. Beware the attorney who only prepares wills. In the event that you have a last will and testament as the vehicle to distribute your property at your death, your estate will go through probate, absent a few exceptions for small estates. And who normally is the person who probates a person's will once they die? The attorney who prepares the will. Now, I'm not saying that if your attorney has recommended that you get a will that they are doing something that is against your interests. However, it's my opinion that in the event that you speak with an estate planning attorney and they do not even offer you or educate you, offer you the option of a revocable living trust, in my opinion, either A, they are inexperienced, or B, they are not serving your best interests. Just because it is not uncommon for attorneys to do a great deal of wills, possibly at a very cheap price, knowing that eventually they're going to get that probate business, which is going to be significant. As a result, that is, I guess, just kind of my point of view, or what I think when an attorney will not discuss the benefits of a trust with their clients. All right, well, that's all I have for today. I thank you so much for watching. If you have any questions, please feel free to give me a call, 402-908-5699. Or you can feel free to check out my website, www.clinchlawfirm.com. There is a wealth of information available. You can also schedule an appointment online. I try to write blogs about once a week, just about a variety of different topics, most of which will concern estate planning. So if you'd like to check out some additional information, please check out my website. Thank you once again for watching. I hope I have provided you with some peace of mind.